Okay, so let's begin firstly with some questions from our previous topic, and then we'll proceed. So today we'll be discussing about fundamental rights, with this assumption that you know almost everything. Okay, so let's start. Answer this. Online people, you can also contribute. Messaging is, I think, free, I'm sure. Did you get your second handout? Yes, what's the answer? A, B, C, D, what? C. The 71st Amendment Act 1992 amends the 8th schedule to include which of the following. So there were 3 languages added. Like which 3 were there? So it was Konkani, Manipuri, and Nepali. When was Mathili added? Mathili was added to the 92nd Amendment Act of the year 2003. So this is wrong. Remove 4. We have A as the right answer. Okay. Then one more, please. Sir, we need more voice. More voice. Right. Is it audible now, Chaitanya? And Hari, others? Voice is not good again. Is my voice not good or the clarity has a problem? Is it correct now? Okay. Great then. Then yes, please answers. Please focus here. You will get the hand already. They won't run away in between. Yes. Something. D. B. B for mountain. Okay. Any other answer? Can we go and check our notes if possible? Do you have that notes from yesterday? Can you just cross check it? Do you first remember what kind of topic is this? So when you amend the Indian Constitution and try to amend the federal features, then extra step is required. That is a state's approval. But the question here is, what are those federal features that if you amend require state's approval? Right? Please cross check and then let me know. So some people are saying A, Shiva, Ankita, and Sri Teja says B. So lists, any of the list in the 7 schedule is mentioned there. This means list 1 also, list 2, list 3. So how can this not be there? So this is correct. If you amend any list, it requires states approval. Okay. Number 2, extent of executive power of union and states. It's mentioned there. So it's stated here. Conditions of governor's office. Is that mentioned in that list? No, not really. So this is not a part. Right answer is 1 and 2 are correct. A, 1 and 2 only. Are you clear? So that list had a purpose. Should we proceed? Then solve this. Yes, those who mark A, correct. So, what's the answer? We have to say it today only. D. Okay, a bill amending the constitution requires a prior recommendation to the President of India, yes or no? No such condition for such bills. When a constitution amendment bill is presented to the President of India, it is obligatory for him to sign yes. Which amendment act made it mandatory? 24th of the year 1971. Oh, so this is correct. So one is wrong. This means we can actually get the answer. The answer is B. A constitution amendment bill must be passed by both the Lok Sabha and the Rajya Sabha by a special majority, and there is no concept of joint sitting is also correct. Oh, great. Now, this question from 2013. B. Okay, very good. All correct so far. What's the answer? D. A. B. An amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. Is it correct? No. Any house. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by legislature of how many states? Half the states, not all the states. This is not required. So both are wrong. Right answer is D. Neither 1 nor 2. We discussed preamble also. So question from preamble. Is preamble a source of power? No. It's not a source of power, right? So on its own, it might not have any legal effect. So what's the answer? D. Because preamble has to be read with other parts of the Constitution to derive a better meaning. So see, it's not a part is wrong. It is a part. It is a part and has same legal effect. Is wrong. Now it is a part but has no legal effect. This is actually correct as a statement. But D is a better statement to make. That it is a part of the Constitution has no legal effect independently of other parts. The preamble and other articles need to be read together to derive a better meaning of what is mentioned in the preamble. Hence, right answer is D. Okay, we are choosing a better statement between A and D. Yes, everybody, correct answer. Very good. Now, this question. Ankita Shiva Shri Vaishnavi Dikshit. How do you safeguard liberty? What's the answer? Silent. What's the answer? Firstly, B is wrong, right? I hope you are aware of this committed judiciary. Remember? So once we were discussing about the ADM Jabalpur case under emergency, I mentioned this phrase called committed judiciary. Long time ago, of course. So committed judiciary means what? What is the meaning of this phrase? Committed judiciary. Committed judiciary is a negative term. Okay, in public administration, it means judiciary which is committed towards upholding government's policies. That's the meaning of committed judiciary. Okay, so the task of judiciary is not to uphold government's policies. The task of judiciary is to uphold constitution. What if government's policy is wrong? Right? Then the court should not be upholding that policy. So committed judiciary means committed not towards the constitution but towards the government. That makes judiciary non-independent. Okay, so this is a negative concept, the opposite of which is called an assertive judiciary. A judiciary which asserts itself. Clear? So committed means committed towards the government, executive. That's the idea of committed judiciary. Anyway, so C is the answer, elected government. Like China has elected government and complete liberty. See. So elected government may not be a guarantee of liberty. It depends on how fair the election process is. How many options do you have? Hundreds of things are required. Okay. So separation of powers. Why? Because if you have separation of powers, you have checks and balances. And that is why this is amongst these the best safeguard for liberty. Separation of powers, checks and balances, not elected government. Are you clear? And committed, we know what is wrong. Done. Okay, Asha and Soumya, correct answer. Meaning of liberty. Liberty to and liberty from. So I had told you that we'll always use the positive meaning of liberty. Okay. So please use the positive meaning of liberty, not the negative meaning of liberty. What's the answer then? This is not liberty. Absence of restraint is the negative meaning of liberty. Liberty from opportunity to do whatever one likes. That's not possible. Again, extremely negative. So finally, opportunity to develop oneself fully. This is the liberty to develop oneself fully, the positive meaning of liberty, which is also the right answer. Okay. When the state provides you with avenues for development, that makes it opportunity to develop oneself fully, the positive meaning of liberty. Yes? Oh. Dikshit and Chaitanya, correct? We are referring to 26th January 19. At that time, what was the status? This means in the preamble, some words were added later on. Which three words are added later on? Sectional and integrity. So this means these two are added later on. So we already had a sovereign democratic republic. This means B is the right answer. This was from amendment itself, Article 368. As per Article 368, the Parliament may amend any provision of the Constitution by way of addition, variation, or repeal. So all three can be done. D is the right answer. Easy, simple, straightforward. Okay, one from basic structure. Please read carefully. Rajkiran, Soumya, Dikshit. Asha, Joel, all correct. Shiva. What's the answer? D. The Constitution of India defines its basic structure. Wrong on both the grounds. Firstly, there is no definition, and secondly, basic structure is not mentioned in the Constitution, so one is wrong. So we remove these two. The Constitution of India provides for judicial review to safeguard citizens' liberties. Now, this can be a slight confusing statement because it says provides for, right? And though we do have elements where you might interpret it to mean judicial review, though it's clearly not mentioned anywhere. That's the point. So, strictly speaking, it is not mentioned, which makes it actually incorrect, and D being the right answer. But still, I understand that anybody can get confused with this very vague word, provides for. So, there is nothing you can do. You'll have to take it in the more literal sense that is it mentioned or not. So, it is not mentioned anywhere. It was a Supreme Court innovation in which judgment Minerva Mills case 1980. Oh. So, now let's begin our discussion on fundamental rights. Okay. So very easy and simple. Now you have a lot of space to write there. So please write on that particular place only. Don't create 34 different notes. First up, please remember fundamental rights part 3. Part 3, articles 12 to 35. So we'll start with classification of rights. So see, rights are all categorized into some categories. You have something called a legal right or a statutory right. Any right that comes through a law is called what? A legal right or a statutory right. For example, you have the very famous RPA 1951. That's a law which gives every citizen right to vote. Or you have the Industrial Disputes Act 1947, which gives people the right to strike. Right? All these things are available. These are all legal rights, statutory rights. In fact, there is one more law, which is the most important law of our country. And that law is called the Constitution. Is Constitution a law? Yes or no? Yes or no? What do you think? Yes, of course. It's the most fundamental law of the land. Every right mentioned here is called a legal right. But a better way would be calling it a constitutional right. For example, there is an Article 300 capital A, which is right to property. Okay? This is a classic example of what kind of right? Okay guys, so I hope now things are better. Chaitanya, Athar, Nishant. Has it improved? Okay. So this is of course, a legal right, but a better way would be calling it what kind of right? A constitutional right. But inside the Constitution, there is one very unique part, which is called Part 3. Part 3, which contains various types of rights. For example, right to life. Now, this right to life, can we call it a legal right? Yes, of course, it's a legal right. Can we call it a constitutional right? Yes, of course, because it is inside the Constitution. But a better term for this normally is fundamental right. So always remember this, maybe a diagram like this, that you have legal rights, inside that you have constitutional right, inside that you have fundamental right. Okay. IDA stands for Industrial Disputes Act, in case somebody is confused there. Should we proceed now? All done? That's why I drew the diagram there, or else you'd have to take 5 minutes to draw this line also. Beautiful, perfect line, problem, shading, coloring required. Okay. Now let's move on to our rights discussion, but before that, a small point to be made. So fundamental rights are primarily available against the state. So we need to define what is a state. Article 12 defines what is a state. Just for this part, part 3, what is the meaning of state? State means the parliament, state means the state legislature, it means the councils and the assembly. State means government of India, government of state. State means local bodies. State means panchayats and municipalities. Okay, and state also means other authorities. Other authorities, which is a very vague term. For example, say Vishnu IAS. Is this part of state? Yes or no? Why no? Because these conditions are not being met. That's why. Okay. So these conditions are not mentioned in the constitution. They have come from a judgment called Ajay Hasia case. Just mentioned here, Ajay Hasia, 1981. Okay. So what is the state? Any body which is created by a law or government order is a part of state. Okay. Any body which is substantially controlled by the government is a part of state. Like all these PSUs and all, they are substantially controlled and there is no percentage. Are they clear? At 51%, there is no fixed percentage. It depends. The court has said that what is meant by substantial control? If the body will not be able to perform its day-to-day activities without government funding, that is enough to call it substantial control. It can be 20% also. The point is that the body is dependent on government for its day-to-day administration. Clear? That is called substantial control. Then, if it performs public and sovereign functions, like all these people who get the tenders for building the bridges and roads, etc., government contracts, you are performing government's function. Or police, intelligence, they are performing sovereign functions. So they are also part of state. Raw, like you saw in this movie Dhurandhar. Have you seen Dhurandhar? And then it enjoys government monopoly. Government monopoly meaning a monopoly given to it by the government, like say IRCTC, to manage the catering in the railways. Monopoly by the government. It's a private enterprise, but it enjoys a monopoly. Are you clear? So let's say today the government says that in our country orange colored clothes will be manufactured only by RSS, nobody else. Then in that case, RSS will become a part of state as far as the manufacturing of clothes is concerned. Because government has issued an order to give it a monopoly over certain area. Are we clear? That's called a government induced monopoly. If you create a monopoly on your own, then that does not make you a part of state. For example, if today the government says that all the coaching schools need to shut down, only Vishnu IAS with a single coaching institute in the country, then Vishnu IAS becomes a state because government monopoly. But if Vishnu IAS becomes the most popular coaching institute on its own because of great teachers like me, these are great students like you who perform very well. Now, if it becomes the best institute and all institutes shut down slowly on their own, then this doesn't make it a part of state because it is not a government monopoly. It's performance-based monopoly. To give you a simple example, there is a very popular body in the country called Board for Cricket Corruption or Board for Control of Cricket in India, BCCI, right? BCCI is not a part of state. I hope you are aware. BCCI is a private body. You might say that it is it is a monopoly in cricket. No, it is a monopoly on its own. You have other small cricket clubs also. In fact, before IPL, there was this club called, this series called ICL. It could not survive because all the players had signed their contract with BCCI. Tomorrow you start your own cricket league, no problem. If you can hire Virat Kohli and Rohit Sharma and all, then nobody will watch the BCCI cricket. BCCI is just a Tamil Nadu-based cooperative society. BCCI is not a part of state because the monopoly over cricket that it has created is on its own. Okay, basic information. Now, Article 13 has two important aspects. So, Article 13 very simple. It talks about the protection of our fundamental rights. First clause says that any law which was there in force before the commencement of this constitution. What is the date of commencement of the constitution? You saw this yesterday, 26 January 1950. So 26 January 1950. So any law which used to exist before that commencement date, if it violates any fundamental right, that law is cancelled automatically. Okay, that law cannot continue. Doctrine of eclipse. It shall be void to the extent of such inconsistency. So if let's say there is a law which has multiple provisions, one provision violates fundamental rights, the entire law is not cancelled. Only that provision is cancelled automatically. Are you clear? This means we protect our fundamental rights. And also the state, which is under Article 12, definition state cannot make any law which takes away or reduces your fundamental right. Laws cannot be made. Are you clear? You can amend, but can't make a law. Okay. And what's the meaning of law? Law includes things like ordinance, order, bylaw, rule, regulation, notification, customs also. Any custom in the country which violates your fundamental right, custom which violates the fundamental rights, that custom has to be stopped immediately. It cannot continue. Are you clear? The state is prohibited from making any law that takes away or abridges. Abridge means to reduce, lessen the fundamental rights. Any such post-constitution law is void, ab initio. On its own, automatically it is void. Are you clear? We don't need to make a law to remove it. So this is Article 13. Very simple. Understand this point that you cannot make a law to take away anyone's fundamental rights. And law has been defined like this. So law also includes all these things. Great. All okay. Now let's come to our fundamental rights. Some say clear, some say not clear. So how many fundamental rights do we have? 6. Okay, great. So we have these 6 categories of fundamental rights. You must remember the categories. It's extremely important. So right to equality from 14 to 18, right to freedom 19 to 22, right not to exploitation, right against exploitation. 23-24, right to freedom of religion, 25 and 28, cultural and educational rights, 29-30, and right to constitutional remedies, Article 32. There was one right to property, we'll discuss that shortly. It was repealed or removed. It was repealed by an amendment act. Laws cannot be made to take away fundamental rights. Amendments can be done. Are we clear? There is a difference between a law and an amendment. Law requires a simple majority. Amendment requires a special majority. Article 360. Okay, let's come to firstly Article 14. Equality before law and equal protection of laws. Article 14 has 2 parts. The first part, read here, equality before law. What does it mean? It means that all manner of people are equal in the eyes of law. No special treatment to anyone. It is a part of this concept called rule of law. What is meant by rule of law? In the simplest of words, rule of law means limitations on state. Okay? Limitation on state. Clear? That is what is rule of law. Limitation will be imposed on state. No person is above the law. Everybody is equal in the eyes of law. And law applies equally to all people regardless of their status, position or wealth. Okay. It also ensures absence of any special privilege. This is called rule of law. We also have a definition of rule of law. Rule of law is a very unique concept which has been there since the times of Plato and Aristotle. There was a British jurist called Albert Venn Dicey. That Albert Venn Dicey gave a definition of rule of law. These 3. These 2 are applicable in India. Number 1 and number 2. Third one is not meant for India. Okay. So what is the first principle of rule of law? no man is punishable except for a distinct breach of law established through ordinary courts. Meaning, very simple. You can only be punished for breaching a law that exists at that point of time. You can't be punished randomly, arbitrary manner. That's not allowed. That's the beauty of rule of law. So when we say we have rule of law, we are saying that the rule is of law, not people. Earlier, kings used to govern. Today, their mood is nice, no problem. Tomorrow, they're upset, death sentence to everyone. Arbitrary use of power. But rule of law says that people don't rule, the laws rule. Whoever comes to power, his task is to enforce the existing laws in the country. That limits the person. That limits the power of the government or the state. Are you clear? That's the concept. Second thing is, of course, equality before law. So this idea that no one is above the law, regardless of status or office. All manner of people are equal in the eyes of law. But there is an exception. There is an exception. An exception is Article 361. You know this Article 361? This refers to immunity of the president and governor. Do you remember? Governors and presidents, they cannot be taken to court while in office. You cannot file a criminal case against the president or governor. You cannot imprison them while they are in office. Even if they commit a crime, you can't. You have to firstly remove them from post and then arrest them. Are you clear? So special treatment. If we commit a crime today, jail immediate. But if president commits a crime, no problem. So some people are exceptions. Or diplomatic immunity. Yes. Through the international conventions, what do? If let's say some diplomat from a foreign country comes to India and he or she commits a crime, we can't punish them. We have to send them back to their parent country, and that country will punish them. Same thing applies to us also. If you clear the exam, become an IFS officer, and then you are sent to some country and you commit a crime there, that country cannot punish you. You will be sent back to India and we will punish you. You can try it in future. Okay. And then parliamentary privilege, the privilege extended to our MPs, MLAs, MLCs, that inside the parliament, they can speak anything and no court case can be filed against them. That is why MPs need to understand that outside the parliament don't say nonsense thing, but inside the parliament say any nonsense you want, nobody cares. That is why the MPs, let's say recently, Didi from West Bengal, she was constantly in the state assembly shouting Modi chor hai, etc. all these things. Why? Because inside the assembly, she has the protection. You can't file a case against her for what she says inside the assembly. But the innocent eligible bachelor of India, Rahul Gandhi, he always makes statements outside the parliament, and that is why defamation case is filed against him. That's his problem. Somebody has to explain to him that if you want to make all these remarks, please make it inside the parliament. No court case can be filed against you. Right? So that is a knowledge gap there for him. Okay, so if he says these things inside the parliament, then no problem. But who will tell? That's also something. The second part of our Article 14. So see, Article 14, to summarize, it's very easy to understand. Article 14 means state cannot have any arbitrary power. Are you clear? Limitations on the powers of state. And this entire concept of Article 14 to 18, they all refer to, you can mention here itself, civil rights. You know what are civil rights? Civil rights are rights of non-discrimination. Just mention that civil rights. Like in USA, we had the rights given to blacks. So that is called civil rights, non-discrimination. So that is Article 14. The second part of Article 14. So this part borrowed from
UK, and this part borrowed from USA. Equal protection of laws, which also is very logical. Why? Because second part says that we cannot have the same law for everyone. That might not be fair. To ensure fairness, we should treat different people differently. Okay? Like should be treated alike. For example, somebody earning, say, 1 lakh rupees per year and somebody earning 1 lakh rupees per month, can we impose the same income tax on both of them? That won't be fair. This fellow has no money. This fellow is dancing in money. So of course difference, right? So we can't have same laws for everyone. Then it also becomes unfair. The second part ensures that people in similar circumstances are treated in the same fashion. Are you clear? For example, progressive taxation. Your tax rate increases with your increase in income, right? And reservation policy. We don't have equality of treatment in government jobs or schools. Some seats are reserved for some communities, right? So we are treating people differently based on circumstances. If you belong to the SC community, ST community, OBC, or economically weaker section, then you have some reservation for you. Okay? This is something that Article 14 allows. Differential treatment. Are you clear? Limits on states' power, differential treatment. All these parts of rule of law and civil rights. Okay? This part borrowed from UK, that part borrowed from US. This is more negative in nature, that no one is above law, and this is more positive in nature. So we can allow for positive discrimination. Are you clear? One of these small pointers, they can ask questions on any of these small points. Done? Should we proceed now? Okay. Article 15. So Article 15, very simple. This again is a classic civil right of non-discrimination. So I hope you're also aware that some fundamental rights are meant only for citizens. There are 5 such rights which are meant only for citizens. Which 5?
15, 16, 19, 20.
Okay, very good. Articles 15, 16, 19, 29, 30. Don't worry, we have mentioned this towards the end also. So don't panic at all. Okay. So the state shall not discriminate against any citizen on the ground of only 5 things. RRCSP, always remember like this. RRCSP meaning religion, race, caste, sex, place of birth. On these grounds, the state cannot discriminate, not just the state. No citizen can face discrimination on these 5 grounds. This means on other grounds, discrimination is allowed. For example, give me examples. How can the state discriminate on other grounds? Okay. On your financial status, the state does discriminate. What else? What you would say? There are 2 very common things. Age and education. Yes or no? If you are not 21, then you can't sit for UPSC. If you are not a graduate or if you don't clear the exam, you can't sit for UPSC. This is so unfair. Why don't you clear the exam? Equality. But that's the criteria. Right? So, on these grounds, no discrimination. On other grounds, it's allowed. For example, right to vote. You're all citizens, but not everyone gets the right to vote. You get the right to vote only once you become 18. There, so we discriminate. Under 18, no right to vote. Then we have laws for marriage also, age-based. Under 21 can't marry. You can vote under 21. Can decide the fate of the country, but can't decide to spoil your life before 21. Sorry, make your life whatever. Depends on the circumstance. One small point here: if the state cannot discriminate on the grounds of sex, meaning gender, then why do we have girls' colleges? College for girls, yes, problem, violation of right, court case, dharna, protest, should we do it tomorrow? Of course not, don't jump immediately, read the third clause, same article. Nothing in this article shall prevent the state from making any special provision for women and children. So state is allowed to make special provisions for women and children. Are you clear? Okay, great. This clause 1 says that the state cannot discriminate. Clause 2 says that other people can't discriminate. So even you cannot discriminate against any citizen on the grounds of what? RRCSP, religion, race, caste, sex, place of birth. Be with respect to, yes, Chaitanya, age, economic, education, culture. Okay, this means access to shops, public restaurants, hotels, places of public entertainment, whatnot. Here, if you are running a shop which is open for all, you cannot discriminate on the grounds of RRCSP. If you, let's say, have a place which you want to rent out, and somebody comes and says, I belong to some religion, and you don't give them the place, that is violation of Article 15. Okay, but if the same person you ask, and a lot of these landlords will ask, are you a non-vegetarian? Right, and then you say, yes, I eat 3 times a day. And then they don't give you the flat. Does that violate Article 15? Yes or no? No, it does not. Why? Because violation only on these 5 grounds, not food habit. Food habit discrimination is allowed. Dress code discrimination is allowed. Clear? Okay. One more thing. Under the same Article 15, this used to be Article 15. But then what has happened is that the First Amendment Act was passed because a Supreme Court judgment was given. And that judgment was called Champakam Dorairajan case, where Supreme Court said that, we cannot allow for reservation in government schools and colleges. But then the Parliament modified the Supreme Court judgment and said that no, we will provide for reservation in schools and colleges. That is the beginning of reservation. So below this, just write like this. Number 1, Champakam Dorairajan, 1950. So what does this article say? This article says that, this court judgment says that what? The state cannot discriminate in government schools on the basis of caste, language, etc. Meaning, no reservation on no reservation in state owned institutions. State owned institutions. Okay, so this was Supreme Court's judgment, but Supreme Court countered it by the Parliament countered it by passing what? First Amendment Act 1951. Okay, this Amendment Act was passed, which is the beginning of reservation in education. Okay, and this is meant for SCs, STs and SEBC. What is SEBC? Socially and educationally backward classes, which is also called OBC. Other backward classes, not caste. OBC is a religion neutral term. If you use the word caste, it becomes a Indic term, but other religions don't have caste. They might have something like caste, we don't call it a caste. So it is classes, socially and educationally backward classes, which we commonly know as OBCs. Then we also have a very interesting amendment which was made recently, which was for the what reservation of which community? EWS, economically weaker section. So what is that reservation? That has come for economically weaker section. 103rd Amendment Act 2019. Reservation for EWS, and this reservation is up to 10%, not more than that. That's the upper limit. You can just mention these two facts. They would be sufficient for your prelims. We don't need to do research for the prelims purpose. This would be more than enough. Yes, Dikshit, correct. EWS 103rd Amendment Act up to 10%. So we have provided the maximum limit 10%. Okay. What's the income level for EWS? Any idea? 8 lakhs. This is 8 lakhs per annum. Recently there was a controversy also about one lady who had cleared the exam. What is her name? Purva Chaudhary or somebody. Pooja Ketkar is a legendary lady from different. Just this time, a lady had cleared the exam, her rank I think around 530, 540 or something. But the problem is that there are a lot of Instagram photos of her in foreign locations with costly purses and sandals and dresses, Prada bags and all. And she has gotten selection under EWS category, right? I think maybe the OBC or EWS category, she has gotten the reservation benefit. Okay, so these things sometimes you have, you know, how easy it is to get a caste certificate in the country. Go and write the circle officer and they'll issue any kind of certificate. I am not saying all this. Other people say all these things. I have no clue. Right? Are you clear? Okay. So you can go home and search for the photos and all. Not right now. What is the point? So that's about it for Article 15. Let's now move on to the next provision, which is Article 16. Article 16 is for reservation in public employment. So you know very well that there shall be equality of opportunity for all citizens. Again, Article 16 is also meant for citizens only. Please circle that word citizens. You remember that it is meant only for citizens. And here also, no discrimination on the grounds of RRCSP, but 2 extra grounds. So, religion, race, caste, sex, place of birth, this is extra, descent and residence. That is why residence-based reservation is not allowed in the country. Only Parliament can provide for residence-based reservation. Okay, please remember this is very important. Only Parliament can make laws to provide for residence-based reservation in government jobs. For example, for Andhra Pradesh and Telangana, there is an article called 371D, which allows these states to give reservation based on people living in these states. Same goes for the Kalyan, Karnataka. So in the Kalyan, Karnataka, that is the northeastern part of Karnataka, you have reservation for them. Then for Maharashtra, Gujarat, Schedule 6 areas, etc. Center can provide. States cannot provide. If state makes any reservation on the basis of residence, Supreme Court cancels it. Are we clear? There is a very old judgment for Pradeep Jain case where Supreme Court has said that residence-based reservation is not allowed. Are we clear? So how do states provide reservation then? Based on language. They are very smart. Language-based reservation. So now if Tamil Nadu wants to benefit its own people, it can simply say that for certain kind of jobs, you have to have working knowledge of Tamil. Now why would a Bengali have working knowledge of Tamil? Makes no sense. So it benefits the locals only. Same goes for Maharashtra, same goes for West Bengal. A lot of states have language-based reservation because language is not a criteria. You cannot discriminate on these grounds. On other grounds, discrimination is possible. For example, education. For example, language. So normally states use language as a criteria because residence with reservation is not allowed. Are you clear? Should we proceed? All basic information which you have already covered, just a recap, revision. Done? Okay. Now, important provision, please remember, this is the reservation in public employment. So, did you observe one small point that Article 15 did not talk about reservation in education. It started from the Parliament's Amendment Act. Yes or no? The first Amendment Act. That's how we brought reservation in education. But reservation in government jobs has been there right from the advent of the Constitution. This is Article 16 Clause 4. This is the provision which provides for reservation in government jobs. It has been there since the beginning. It was not added later on. Our makers have added this, all thanks to Ambedkar. Okay. So, state can make reservation in favor of backward classes. State meaning what? Article 12 definition, state. If they are not adequately represented in the government jobs. Are you clear? If any group is not sufficiently represented in government jobs, then they can do what? The state can provide for reservation. Okay. We have reservation for various categories. Scheduled castes, how much is that? 15%. Scheduled tribes, 7.5%. SCBC, 27%. EWS, 10%. And then we also have persons with disabilities, 4% extra. Are you clear? You know, despite the reservation parameter, there exists an article in the country called Article 335. Let's read the first part of Article 335. It says that the claims of members of, I'll explain this first. It simply says that the state will provide for reservation for SC/ST, no problem. But just because I have to provide reservation, I cannot compromise with the efficiency of administration and governance. We can't hire any random person. We have to deal with governance also. So yes, my motto is to provide reservation, but we cannot hire any random person. You have to meet the basic criteria, right? So the efficiency of administration cannot be compromised. Though sadly, there is no definition of what is the meaning of efficiency of administration. That we don't know. How do you calculate it? Not defined. But let's read now. The claims of members of SCs and STs shall be taken into consideration, of course, but consistently with the maintenance of efficiency of administration. Are you clear? In the making of appointments to services and posts in connection with the affairs of the union. Clear? No doubt? Any issue or concern here? So we have to take into account also efficiency of administration. But then what happened was that after the very famous Mandal judgment, a modification was made. So the entire second paragraph was added through the 82nd Amendment Act of the year 2000. This is a later addition. And what does this provision say? Please read. Provided that nothing in this article shall prevent in making any provision in favor of members of SCs and STs for, underline, relaxation in qualifying marks or lowering standards of evaluation. So government said that we can modify the cutoff, we can reduce the cutoff, we can lower the qualifying marks, we can change the evaluation standards, but we have to provide reservation for SCs. Original article said that our prime purpose is to maintain efficiency of administration. Are we clear? Our prime purpose is to maintain this. So this cannot be compromised with. But then the parliament said no, we can compromise with anything. Our prime purpose is to provide for reservation. Are you clear? Change of stand. And to provide for reservation, we can also have a different cutoff marks. Different cutoff marks are there for different categories. And we can also lower the standards of evaluation. If the purpose is to provide reservation, we will provide for it. Okay? So this is important. Dikshit, sir, Article 16, Clause 4A for reservation in promotion, yes, yes, yes. Not small a, capital A. So this is with respect to reservation, sufficient information. Then two things to remember is Article 16, Clause 4A. This provides for reservation in promotion. But this reservation in promotion is meant only for which people? Scheduled castes and scheduled tribes. It is not meant for OBCs or EWS. And just to summarize all this, please remember, reservation is not a fundamental right. Okay, you can write this somewhere. Reservation is not a fundamental right. This is a Supreme Court judgment. Reservation is an exception. What is the right? The right is non-discrimination. That state will not discriminate. Reservation is an exception. If you get a question like this, please remember, reservation is not a fundamental right. Are we clear? Okay. This covers this sufficiently. Should we proceed now? All done? Okay. Then let's come to Article 17. Article 17 talks about what? Untouchability. Again, please remember this word untouchability is not defined in the Constitution. Okay, there is no definition of untouchability in Constitution. Okay, not defined. We simply can say that untouchability is any form of social exclusion or discrimination, but there is no definition as such of untouchability. And this is the article. Untouchability is abolished in the country and its practice in any form is forbidden. Forbidden. Full stop. The enforcement of any disability arising out of untouchability shall be an offence, which shall be punishable in accordance with the law. Which law? This is the law. PCRA, very popular law. PCRA, Protection of Civil Rights Act. This law was originally called Untouchability Offences Act. In 1976, this law was renamed to PCRA, Protection of what? Civil Rights Act. Are we clear? Now, what is the provision in this law? Firstly, what are the offences? Enforcing religious disability, meaning if you enforce any kind of religious disability on people, that you don't allow them entry into a place to worship, temples, etc., that's called untouchability. Or if you enforce social disability, meaning you don't allow some person to open a shop, let's say an SC person, you tell him that you can't open a shop to sell God's idols. Okay, that is called enforcing social disability. That's also an act of untouchability. Then if you refuse to admit any person to hospital, let's say some SC person is not being admitted to hospital, that's also untouchability. Refusing to sell goods or render services, untouchability. And if you try to practice or preach untouchability, try to justify it, that it's a great thing, we used to do it in the past, let's revive the old culture of our country, etc. All that is wrong. Are we clear? Please don't. And then if you do it, you can be punished with a long jail term of 6 months and a huge fine of 500 rupees. Are we clear? That's the real punishment is this one. Disqualification from contesting elections. For how many years? Very good, 6 years. 6 years plus jail term. Whatever jail has been given to you, plus extra 6 years. You are disqualified for 6 years at least from contesting elections. This is actually a provision of RPA. RPA 51, Section 8(1). Section 8, subsection 1. Clause in Constitution, subsection in laws. Are you clear? So, if you will practice untouchability, you will not be allowed to contest elections for 6 years. And also, this is where court operates on the presumption of guilt. So normally, have you heard of this term, innocent till proven guilty? Yes or no? You are deemed to be innocent till you are found to be guilty. But under untouchability, it's exactly opposite. You are assumed to be guilty. The onus is on you to prove that you are not guilty, not on the law enforcement agencies. Are you clear? It works in an opposite manner, very harsh law. Also, the offense is cognizable and non-compoundable. What is a cognizable offense? Arrest without warrant. Cognizable offenses are those offenses where you can be arrested without a warrant also. And what is a non-compoundable offense? So it comes from the word compoundable offense. Compoundable means petty offense, small offense. So compoundable offenses are those offenses where out of court settlement is allowed. Like say pickpocketing. If you pick somebody's pocket, you steal somebody's purse, the public catches you, they beat you firstly badly because they're also angry, frustrated. When the police comes, the police might slap you and take the purse back and let you go. Right? That's it. They might not take you to court. That's called a compoundable offense, petty offense. Non-compoundable offense is a serious offense where matter has to go to court. You cannot simply practice untouchability and say, I'm sorry, by mistake it happened. Okay? Just like murder. Murder is a non-compoundable offense. You can't kill someone, sorry, by mistake, it's okay, please forgive me. Are you clear? So, no out of court settlement, non-compoundable. Yes, Sriteja, absolutely correct. No out of court settlement. Done. Mind you, this Article 17 and the PCR is meant for scheduled caste people, not scheduled tribes. Okay, because this is meant for untouchability. SCs. Okay. Done. Can you proceed now? This was Article 17. Now Article 18. Article 18, a very simple article. It talks about what? Abolition of titles. So we will not give titles to anyone. Why won't we give title to anyone? Because titles create inequality in the society. So we cannot give any kind of title. The only exception is that we can give some titles. Which titles? Military or academic title can be given. Otherwise, state will not give any kind of title, come what may. Okay, but we can give military or academic titles like doctors, etc. Nowadays, ER, engineers, they're also giving themselves their own title. Right? Especially in their marriage card, they write ER. Or openly claiming engineer today is not a good thing to do. Very still, but still people are claiming themselves to be engineers. Nothing against engineers. Sorry. I myself have an engineering degree also. But that's the whole point, right? Half the country is full of engineers. And especially in cities like Bangalore and maybe the financial district side of Hyderabad. And they say it goes to it lands on engineer only, 99% times. So anyway, one more thing, if tomorrow, let's say this, we have your, did you get the questions yesterday evening? Some 10 questions. Did you solve those questions? Yes. Under the shock, what question? Which question? Questions were sent to you. How were they sent? Mail. App. Okay, so on the app it is there. Okay, download the app. I'm not marketing, just telling you. Questions are important. So they have prepared a question, you can just practice it. So let's say after all these tests and all, Vishnu IAS gives a tag, Prince of Vishnu IAS, Princess of Vishnu IAS. This award is given, this title is given based on performance. Is this allowed? Yes or no? No? Yes, it is allowed. Why? Because state will not give title. Vishnu IAS is not state. It's a private enterprise. Nobody cares. Right? So we can give titles. Your mom is calling you Raja Beta, Kyari Vidya, etc. You are calling your loved ones Babu Shona. That's also title only. All the cringe-worthy names that you call, right? What are they? Titles only. Those things are allowed. You do whatever you want. All the Korean heart emoji drama that you do, it's all okay, no problem. But state will not give any kind of title. The limitation is on state. State meaning Article 12. Clear? Okay. Then if you are an Indian citizen, you can't accept foreign titles. Okay. Foreign titles can't be accepted. Regulations, etc. allowed. Titles can't be accepted. Then if any foreigner is working in India under some government company, okay, then he cannot accept any title from any other country without resident's permission. So even foreigners, if they are working in India under some office of profit, for example, there is a foreigner who is acting as a teacher, guest lecturer in some college in the country, government college. Okay, a foreigner working in an office of profit post, getting money from government. So they cannot accept a foreign title without resident's permission. There's a criteria. Okay, and lastly, people like you, all those government employees, etc. All those people who are holding any kind of government posts, you cannot accept any kind of gift, salary or jobs from foreign countries without the president's permission. So if you're an IFS officer, you get posted in some foreign country and they come and give you gifts and all, don't take it home immediately. Okay, that is meant for the government, not for you personally. Are you clear? So please don't take those home. Oh, voice problem again. Okay, so that's with respect to the titles. Clear? So in fact, there are a lot of these limitations on IFS officers and all, and civil servants. You can't marry a foreigner also. I mean, you can, but you have to take the president's permission. Without president's permission, you can't marry a foreigner. Okay, so if you are posted outside, you can fall in love, no problem. But for marriage, you don't need parents' permission. You need president's permission. I think that's a mark of your enhanced status also. If right now you want to marry somebody, you need parents' permission. But if you clear the exam, then the country president will allow you. Motivation. Okay, this is today's motivation, that please clear the exam so that the president can allow you to marry a foreigner. But for that, you have to date a foreigner, make them fall in love with you. That requires itself a lot of trouble. So that's okay. One more thing. In our country, we have these things called civil awards. We have 4 categories, 3 Padma awards and 1 Bharat Ratna. You can see the criteria. This award is given by the government, center. Okay. Now, this award was started in 1954 by Chachaji, Pandit Nehru. And see, Padma Shri is given for distinguished service. Padma Bhushan for distinguished service of high order. Padma Bhushan, exceptional and distinguished service. And Bharat Ratna for exceptional service of the highest order. What is all this service? You don't know. That completely depends on government. Okay? This means if you like the government, Padma Shri. If you love the government, Padma Bhushan. If you're really crazy for the Padma Bhushan, if you're willing to die for the government, Bharat. That's the only understanding. Two more things. There was a time in 1977 that these awards were suspended. When Janata Party came to power, it said, why are we giving these awards, calling some people Bharat Ratna? Why are you calling someone Bharat Ratna? So what are others? The stones of Bharat. Everybody is a Bharat Ratna. So they stopped the awards. In 1980, Indira Gandhi came back to power after emergency. She again started the award. How dare you? My papa started this award. So she revived the awards. But again in 1992, people challenged this award that it violates Article 18. You are giving titles. But then the Supreme Court said that no, these awards are not titles. So two important things. Number one, these awards, they are not titles under Article 18. So there is no problem whatsoever. Okay guys, we are looking into it. Hopefully we'll have this resolved. So these awards are not titles. Are we clear? You can freely give this award. Second, they were suspended twice, but later on the court accepted it. One more important point, I think this comes from your state only. So these actors like Mohan Babu and Brahmanand, these people, they started using the Padma Shri in front of their name. Okay, that is not allowed. You can't use these titles in front of names. So if you get this award in future, don't go to other office. Come on, change my name now. Padma Shri ABC. Not allowed. If you do this, the award will be taken back from you. So, can't be used with name. I mean, you can call somebody Padma Shri or Padma Vibhushan, etc., but officially changing it, not allowed. Okay, so sir, when you're turning towards laptop screen, the voice will be good. Otherwise, not good. Oh. Is it okay now? So others all clear? So these awards were started, and see, I mean, there is no limit to how many awards can be given, but we have a Bharat Ratna official limit. Okay. Sri Teja, if not titles, then why are we not allowed to add? Because again, it takes away the importance and respect for the award. Okay. So the award is a mark of respect for individuals. So let's not use it very casually. We use it in only selective situations. We won't change our name officially. That's the reason. That's what the court felt. So maximum 3 per year. Though let me clarify, there have been situations where we have given 4 Bharat Ratnas also and 5 also. Like last time, 5 people got the Bharat Ratna. Okay, including Advani ji, MS Swaminath got the award, even Narasimha Rao, of course, you know very well, got the award. Charan Singh got the award, Karpuri Thakur got the award. 5 people. But officially the limit is 3, maximum 3 per year. Okay. See, these awards have a lot of problems. To give you a sense, the president, meaning the prime minister, the government, yes or no? President has no power in the country. He is always bound by advice of Council of Ministers, Article 74, yes or no? So, in short, this award is given by the prime minister. In 1955, who was the prime minister? Pandit Nehru. In 1955, Pandit Nehru got the Bharat. He gave it to himself. Though in the press and all they had published these things that Nehru is not willing to accept the award. The cabinet has forced Nehru to accept the award. Then in 1971, who was the prime minister? Indira Gandhi. Who got the Bharat Ratna? Indira Gandhi. She said, if Papa can do it, I can do it. So gave the award to person. And you'll be surprised that in 1990, Rajiv Gandhi got the Bharat Ratna. And he got the Bharat Ratna with one more person that year, a very unimportant person called Dr. Ambedkar. So Ambedkar got the award in 1990. after Indira Gandhi, etc. Everybody. And Sardar Patel got the award in 1991. Right? So that is really shameful that we feel that contribution of Indira Gandhi and Rajiv Gandhi was more than Sardar Patel, but that's the problem of this award. It is given by the center government. So a lot of manipulation happens. Clear? Anyway. Okay. Let's see for how long. Then we have some constitutional bodies. We have 3 such bodies: NCSC, NCST, and NCBC. Please remember the article 338. Now video is not clear. National Commission for Scheduled Castes. Article 338. National Commission for Scheduled Tribes. 338A, and for backward classes 338B. Okay. So NCSC was established in 2003 after bifurcating this common body. So you can see the purpose. So what? Also remember a very important point. Commission for Scheduled Caste is meant for which body? Which group? SCs and Anglo-Indians. Okay, both. Are you clear? We have very less population of Anglo-Indians, so it makes no sense to have a separate body for them. So the same NCSC also serves the needs of Anglo-Indians. Are you clear? So both Anglo-Indians and scheduled castes. So you can just go through their functions. Very simple. They investigate and monitor and all these safeguards. They inquire into complaints. They participate in the planning process. Nothing to discuss here. Just the functions. Also, the NCSC has powers of a civil code. This is important. This point is important. Put a star mark here. Done. So what are the powers of civil code? I have explained here. Powers of civil code simply mean, if you understand it, any body which has the authority to ask you to submit any evidence on oath, has the authority to order you to come and be a witness. That body is called a body which has the power of civil code. Are you clear? And this is mentioned in the Constitution also, that summoning and enforcing attendance of any person, requiring the production of any document, receiving evidence on affidavit, requisitioning any public record from a government office, etc., or issuing summons for examination of witnesses. Powers of a civil code. That's it. Done. We have other 2 bodies. So NCST, established with the same intact, and very important to note, NCBC. NCBC was formed in which year? 2018. Okay, please put a tick mark so you remember, underline it. NCBC as a body was formed with the 102nd Amendment Act 2018. Are you clear? This kind of information is important for your prelims. So please keep that in mind. Done? Should we proceed now? Then we are done with right to equality. Next is right to freedom. So right to freedom again has 5 articles: 19, 20, 21, 21A and 22. So first of Article 19. Again, Article 19 is meant only for citizens. Please circle this word, citizens. And look at this point very clearly. Article 19's first clause has 6 different sub-clauses. 7, but 1 was repeated. Right to property. So all the citizens shall have the right of what? Speech and expression. Assemble peaceably and without arms. Arms meaning ammunition, weapons. To form associations or unions or cooperative societies. Underline this. Cooperative societies was added later on with the 97th Amendment Act 2011. Okay, then to move freely throughout the territory of India. to reside and settle in any part or territory of India. And F has been repealed. This actually was to acquire, hold, and dispose of property. This was what was mentioned, but it has been repealed now. To acquire, hold, and dispose of property. Done? Then the last one, to practice any profession or to carry on any occupation, trade, or business. We call it POTB. Remember easily, POTB. Why POTB? Profession, occupation, trade, business. Clear? So to practice any profession, occupation, trade, or business. POTB. Done? Should we proceed now? So please understand that every such provision has a list of restrictions, because our rights, fundamental rights in our country, they have limitations, they have restrictions, they are not absolute in nature. So Article 19(1)(a), this one, this is 19(1)(a), this is 19(1)(b), so on and so forth. The restrictions are mentioned in separate clauses. Okay, two things. These restrictions can only be done by law. Okay, and the restriction must be reasonable in nature. You cannot impose unreasonable restriction on fundamental rights. Two important criteria. Number one, the restriction must be reasonable. Number two, it must be imposed by law only. Are you clear? Let's not forget these 2 points. And then let's see one by one. Let's proceed. So first up, we have 19(1)(a), the freedom of speech and expression in the country. On this, these are the 8 different types of restrictions. Okay, look at this. One single right and hundreds of restrictions. Not 100, 8 restrictions. So lesser rights, more restrictions. That's the problem sadly. Now there are certain things that have been added later on. For example, this first restriction, this was added through the 16th Amendment Act 1963. The same phrase was also added somewhere else with the same Amendment Act. We saw it yesterday. I can't hear. Please. Preamble? Why the word sovereignty we added in preamble? It's already there from the beginning. This, very good. Oath of office of ministers. We saw that yesterday. The entire phrase sovereignty and integrity of India was added in the oath also with the same amendment. Anyway, so that was there. Then number 3 and number 4, which are friendly relation with foreign states and public order. These 3 rather, 1, 2, and last one, 8th one. All these were added through the First Amendment Act of 1951. Right at the beginning of our constitution, we started imposing restrictions on rights, done by the very liberal, open-hearted Chachaji, Pandit Nehru. That's the biggest myth in the country, that Nehru was a liberal person. He banned numerous books, he imposed numerous restrictions, but the narrative is that he was very liberal. So these 3 limitations come from what? First Amendment Act. Okay. Couple of things to remember. That see, freedom of speech and expression, that the right that you have, it also includes some things. Also includes One thing is freedom of press. Even though it is not mentioned clearly anywhere, but Supreme Court in its judgment, Ramesh Thapar case has said that freedom of press is a part of what? Freedom of speech and expression. Or right to know. Know what? About government activities, not a neighbor's phone number. Okay? Right to know about government activities. That is also a part of your freedom of speech and expression. Or right to access information over internet. So I think there is a small confusion sometimes in the minds of people that we have some right to internet. Right to internet is not possible. Okay. If you give a judgment like this, the right to internet, then everybody will go to court and say, I want 100 GB of internet every day. That's not possible. You have right to access information over the internet. That is why government cannot uselessly ban websites. This prevents the government from banning websites uselessly. You can ban websites only through laws and reasonable, logical reasons, not random. Okay. And one more thing that is a part of Article 19(1)(a) is, yes, the freedom of silence. Silence is also a way to express oneself, which you use a lot when you ask questions. The freedom of silence. Now you can claim that I'm just exercising Article 19(1)(a), but don't do that in the interview process. Now, that they ask you a question and say, I'm exercising my right, sorry. Okay. So this is all 19(1)(a). Please mug up all the 8 restrictions. We can have a question on this in the prelims. Done? Should we proceed? Then, next is, I just wanted to explain a couple of things because we have seen questions on contempt of court. So words like defamation and contempt of court are things that you should know. So first up is defamation. It's a part of your BNS section 354. Earlier in the IPC was section 499. So what is defamation? When you make any kind of allegation against somebody trying to damage their reputation. Okay. And when you make such accusation, imputation means accusation. If you make any accusation against somebody, you have the reason that your accusation will harm or damage the person. Okay? Defamation can be of two kinds. Civil, where you seek damage in monetary compensation. A very good example of that defamation is the case of Amber Heard. You know Amber Heard, Johnny Depp? No, you don't know all these people? Okay. Some of you know, others have no idea who are these people. No problem. It's okay. This won't come in UPSC anyway. Don't worry. If you make any baseless remark against somebody, the person has two options. He can go to court and file a case, which is a civil case, where he claims that because of your stupid allegation, my reputation was damaged, and I experienced a monetary loss. So in that Johnny Depp case, what had happened was that Amber Heard, this actress, she had leveled allegation of domestic abuse against Johnny Depp. Because of that, Johnny Depp had to lose out on various movie franchises like Pirates of the Caribbean, etc. So he did not get movies. This means that he had a monetary loss. Okay? So he filed a civil defamation, claiming $100 million in compensation. The other defamation is a classic example against Rahul Gandhi, which was filed. So Rahul Gandhi in one rally in Karnataka had mentioned that why he said Nirav Modi, Lalit Modi, why are only Modi's thieves? So the Modi community became very angry. That what is this nonsense? So they filed a defamation case against him, which was a criminal defamation. In the case of a criminal defamation, you don't want compensation. You say, I want to see this fellow in jail. That will satisfy my heart and mind. So that's called a criminal defamation, where the maximum punishment is up to 2 years, or a fine can be imposed. So in the case of Rahul Gandhi, the case is still going on, but the lower court had given a punishment of 2 years to him, which was then removed by the higher court, but the case is going on. Okay, there are multiple cases against Rahul Gandhi of defamation. He keeps on making all these remarks, but the only problem is he will not say anything inside the parliament. Inside the parliament, he is smiling, laughing, winking his eye, etc. They use the parliament to make all these allegations. I think he has to change his team of advisors immediately, or better, read the constitution properly. That's also an alternative. Okay, anyway, we can't make such comments, especially in this state, with the ruling party in power, like the great footballer who is in power right now. Okay, so second is contempt of court. I mean, see, I understand, I respect the emotions when Messi is there, you also want to, but understand the limitations also. Just wearing a football jersey will not make you a footballer, right? I think we should only allow jerseys to people who know how to play football. Embarrassing for everyone to see. He's standing there, hitting the ball there. What is the Not one, but twice. I mean, after one shot, you should say, okay, not my cup of tea, but again, try it. Okay, no problem. Contempt of Court Act 1971. This is contempt of court. If you make any allegations against the court, that is called a criminal contempt of court. Okay? So if you make statements that scandalize the court, attack their dignity, lower their authority, etc., that's called criminal contempt of court. Second is civil contempt. Meaning, if you disobey court's order, that's called civil contempt of court. Clear? Contempt of Court Act. So this word contempt of court, number one, it is not defined in the Constitution. Something to remember. Second is that contempt of court power is available with court of record. Which courts in our country are called courts of record? Which? Constitutional courts, meaning Supreme Court and High Courts. So only these courts have the contempt power. COR means court of record. Okay, court of record. Done. And one more thing, who will make a law on court of contempt of court? Parliament. Only Parliament can make a law. Can make laws. So contempt of court, when you violate the decorum of the court, you go to court, you are sitting there throwing paper ball on judge from behind, etc. We don't know what can mean. Now, especially with the virtual courts and all, because we have online hearings also nowadays, that becoming more dangerous. Just 2 days back, there was a case where the judges were yet to come, the lawyers were waiting in their own houses, and this lawyer, I think he did not know that his camera is on. His partner came and they were all involved in public display of affection, busy hugging each other and all. And then the camera was on. Then the judges came and he went on to switch on the camera and he found the camera is on. So all that he did could be seen. A similar case happened a few months back also in Delhi High Court. There was a lawyer, he thought the camera is off. His, I think, wife or whatever, I don't know who that lady was, who came and then she was kissing him and he was feeling shy and he was kissing her back, etc. All live. But I think the best, should I say, contempt of court was what happened in Gujarat. I think I need to show you that because just saying that will not make any impact. Let's see if we can find the video. Virtual hearing, Gujarat court. Okay. this is a court proceeding going on. Okay, so judge and these fellow are arguing, and this fellow is actually the washroom, and he's flushing as well. I mean, so this is a situation for this fellow, fully enjoying his life. And here the judge and the lawyers are arguing about everything. And see. So I think this is a bit too much. We should take the court proceeding seriously. Sitting in the washroom and being a part of court proceedings was too casual. So that's where we should draw the line, not be in the washroom. And so this classic example of court contempt of court. Okay. So that's why the judges are afraid of virtual hearings. This is what will happen. And in other things, very simple. This lawyer thing. I can't show you the yesterday's one because yesterday's one is not decent to the class, but there is an old one also which can be. I think this one. This one it's less indecent. So this is a lawyer. I mean, at least check whether the camera is on or off, right? So, but the one yesterday, I think that might not be appropriate because this cross certain boundaries there. So, for more details, please watch the video. So, this is contempt of court. Okay. So, this is called criminal contempt of court. Civil contempt is when you disobey court for it. Okay. So, mostly this is issued against people like you in future. Court gives orders to government and government will not follow the orders. It will delay, so the officers are called, especially IAS officers are called in the court. And then civil contempt can be issued against you. Okay, so that's with respect to contempt of court. Next, we have the right to assemble peacefully and without arms, of course. So in that case, what happens? There are only two restrictions: sovereignty and integrity of India and public order. But please understand, the right to assemble does not include right to strike. Right to strike is not your fundamental right. It's a statutory right. It comes from Industrial Disputes Act. And right to assemble anywhere, that is not included. You can't say I want to assemble my neighbor's house. Not possible. Okay. Also, you can protest, but occupying a public space for indefinite period, that's not allowed. Because if you occupy a public space indefinitely, it also obstructs the other people from using the road. Are you clear? So that limitation has to be understood. Then we have the right to form associations. Of course, you can form any kind of association. It should not violate sovereignty, public order, or morality. Clear? For example, you can't form a terrorist association. You can't claim this is my association, terrorist association. So for that, we have a very good law. What is that law called? The law is called UPA, Unlawful Activities Prevention Act. A very, very dangerous law. Okay. So in future, you can very easily, if you are a police officer, arrest somebody under UPA. Arrest them properly. You know, the conviction rate under UPA, meaning for every 100 people arrested, how many are actually found guilty by the court? Only 2. That's one of the lowest conviction rates anywhere in the country for any kind of law. So UPA is a largely misused law, and UPA is very dangerous in the sense that the government can declare anybody a terrorist. Okay, they can give you a tag that you're a terrorist now, and what will happen? Nothing. They might say it's okay, we don't want to arrest you. You're roaming around here and there, but you're a terrorist. This can also be done. Just to clarify, if you are ever found to be funding a terrorist association, you'll be jailed for at least 5 years. At least 5 years. So when you keep on scanning every QR code and make payments, if that fellow is not in terrorist activities, you sending him money will be seen as funding a terrorist activity. Jail for 5 years. All UPSC plans in there. Prepare there. Okay. Also, think of it. Let's say this class creates a WhatsApp group. Okay. And now normally, after this class is over and all, the group remains, but it's all dormant. Only few people are always sending good morning, good evening, on messages there. Others don't even respond. They just come see sometimes, etc. After 4 or 5 years, if anybody in this group becomes a terrorist in future, then all members of this group, a case can be filed against you for being a member of the group. So please don't join random groups for notes. Let me join this group for notes. We don't know who is the admin of the group. What if he is not in terrorism in future? Okay, dangerous things. That's there. But see, this law is very strict in the sense that terrorism is defined in quite wide variety, including if you ever kidnap a public servant, that's called a terrorist activity. Okay? So, right now, if you are kidnapped, your parents will be called for ransom, the jail said, thank God, great, take him away forever, etc. Whatever. It's a normal offense. But if you clear the exam and then you are kidnapped, it's called a terrorist activity. Motivation. Okay? So, your kidnapping becomes a terrorist activity. And if by any chance you are kidnapped and you die in that process, don't worry. If we ever catch those criminals, we'll give them death sentence. If we catch them. So you can die in peace, that they'll get death sentence. So UPA also allows death sentence. Clear? That's the maximum punishment under UPA, death sentence. Then any kind of hijacking, any kind of hostage situation, it's all terrorist activity in India. Clear? Anyway, then let's move on. Then we have two rights, right to move freely and right to reside anywhere. But these rights have limitations in the interest of general public and for protection of interest of scheduled tribes. So, schedule 5 areas, schedule 6 areas, you can't move there freely. Inner line permit areas, you can't move there freely. You can't reside or settle there, etc. Those limitations are there. And lastly, the right to practice any profession or carry on any occupation, trade or business. There are two restrictions. Sometimes the government can create a monopoly over any kind of trade. Let's say you say that I want to start a business of manufacturing bombs. Government can refuse it, saying no, only we can manufacture bombs. Here, let's say you want to start your own kind of service, police service. You gather some 5-10 friends of yours and you start enforcing laws in the country, making random arrests of people. That's not allowed. Because what the police service, who has a monopoly? The state has not. Only state can hire the police who are very corrupt, sorry, non-corrupt, honest officials. Second, a professional or technical qualification might be required. For example, tomorrow you cannot claim that, I want to conduct open heart surgery. And outside your house, you take out a table and say, come on, open heart surgery, 20 rupees only. You can't start that also. Because that requires a professional degree. Okay? So these are limitations that can be imposed. So remember the limitations also on these fundamental rights. That's it. Then we have Article 20, which has 3 parts. First one is no ex post facto law. What is the meaning of ex post facto law? From backdate. Retrospective effect. So laws cannot be applied from backdate. Are we clear? This means that if and this is meant only for criminal laws, just to clarify. Criminal laws only. This means if you make a law which increases the punishment for a crime today, that law will be applicable from today only. You can't apply it from backdate. Are we clear? That's called no ex post facto law. But this can be done for tax laws. This means I can increase the tax rate and pass the order that this law applies from 1995. No problem. That is allowed. But for criminal laws, you can't apply it from backdate. Are you clear? Second is no double jeopardy. I think you know this. No person can be punished for the same offense more than once. You can only be punished for the offense once. It is meant only for judicial proceedings. Are you clear? For example, let's say in your school days, you got a report card. Poor marks. Teacher beat you first in the school. You went home, your mom beat you then. For the same report card. In eating your father cake, he thrashed you properly. So you are being punished multiple times. You can't claim double jeopardy. If you claim, they'll thrash you again. Okay, so don't claim double jeopardy in such cases. It is claimed only in one case, that is court proceeding. On a more serious note, the example is administrative punishment. For example, let's say you are punished by your company and your promotion is denied to you. After 5 years, for the same old mistake of yours, again promotion can be denied to you. Meaning you are being punished for the same mistake multiple times. It's allowed. But in the courts, you can't be punished. Are you clear? So let's say you commit a crime and the courts find you guilty, send you to jail for 10 years. After 10 years, you come out smiling. The courts know. You're still smiling. Send him back. That's not possible. But if you commit a different crime, one more murder, then that's a different crime. Back to jail. Clear? Okay. Sri Teja, sir, is terror definition mentioned in UAPA? Yes, it is mentioned, but it is there are a lot of vague terms involved in that definition, which are prone to misuse, and that is why you have misuse of impala. Then third one is no self-incrimination. This means that no person accused of any offense shall be compelled to be witness against himself. It means that if the police arrests you and asks you to accept your mistake, you can simply refuse. In these Hollywood movies, have you seen this statement that people make? I have your right to remain silent. And then the people say, I talk to my lawyer only. You can do the same thing. The police arrests you, you can say, I will not say anything. See, it does not really matter. If the police arrests you, they can't force a confession out of you. And even if you confess anything in police custody, that is not admissible in court. Are we clear? If the police arrests you next time, before they slap you, accept everything. No problem. They say, to kill the person, you say, yes, I killed 10 more people. It does not matter. The police has to find out more evidence based on your confession. Only then can your confession be used in court. For example, if the police says, did you kill someone, and you say, yes, I killed, they'll ask you, where is the body? If you say a random place, and there they actually find the body, then your confession will be used. Okay, so please don't reveal or you hit the body. Or don't kill anyone in the first place. That's also possible. So this is with respect to our contempt of court. If any government officer commits any crime, he is first removed from his office and punished by the court. No, there it is not applicable, because removal from office is an administrative procedure. Punishment by court is a criminal procedure. So those are two separate kind of punishments. Also, no self-incrimination does not mean that you will not give evidence to the police. So police can ask you to show your body, give thumb impressions, written signature, give your laptop password, phone password. Some of you might take you to jail, I can't give my phone password because of all the dangerous things inside your phone password. So that's all there. Okay. But again, the same thing, this also is meant only for criminal proceedings, not for civil proceedings. Okay. So all these extend only to criminal proceedings. This was Article 20. Then comes the most important point in our rights, which is Article 21, right to life. Because if you don't have life, then what is the point of other fundamental rights? How will you enjoy this after death? Not possible. Right? So this says no person shall be deprived of his life or liberty except according to procedure established by law. Okay, so there are two terms that we use. The first one is called procedure established by law. So what is a procedure established by law? What is the meaning of this? Whatever procedure has been established, you need to follow that procedure properly. So what is the procedure of law? What is the first step in the criminal justice system? What is the first thing you do? Very good. First thing we do is we prevent a crime. And then we move on to, if a crime is committed, then what do? Then we do a preliminary inquiry first. Just because somebody, if you today go to the police and say that police, I had 5 crore rupees in my house because it was stolen. The police will not accept the complaint immediately. They will say, in your GP there is only 34 rupees. You are claiming 5 crores. They firstly come to your house and inquire to verify whether the complaint is true or not. And then they will conduct some investigation. They will register an FIR. Then they'll conduct investigations. They'll make some arrests. They'll file a charge sheet. What is a charge sheet? List of all the allegations against you, all the laws you have supposedly broken, and then it is taken to court for prosecution. Prosecution where? In court. In the court also, trial takes place properly. You are given a lawyer if you don't have a lawyer, and finally there comes the verdict, which is what? You are, if you are rich, you are acquitted. If you have not committed the crime, you are acquitted. And if you have committed a crime, you are found to be guilty, you are sent to jail or fined, whatever. So this is called the entire procedure. My point is that Dikshit will come to that. So this is called procedure established by law. Now, whose task is it to follow procedure? Tell me. The government, right? Executive, police. Police part of government. So when I say procedure must be followed, I am saying that there should be limitation on executive action. Okay? Executive action is limited. You can't randomly arrest or kill somebody, send them to jail. You have to follow proper process. Laws must be applied fairly. Are we clear? You have to apply the law properly. All okay? No problem? But think of it. We just finish this 21 and then we'll end our discussion today. So there is a more concept which is called, now think of it. We are saying that law is applied fairly, no problem. But what if law itself is wrong? If today a law is made that anybody found eating chicken biryani, veg biryani, will be sent to jail for 10 years. Because calling biryani as veg is a crime in itself. Okay. Now what we do is we tell people don't eat veg biryani. Nothing called veg biryani. Okay. Then we also, if somebody eats veg biryani, then we start inquiry against them. We collect evidences, take photographs, go to their house. From the fridge we take out veg biryani, no chicken inside this. Finally, we arrest them, we take them to court, the court finds guilty, the court punishes. Did we follow procedure? Yes or no? But is the law justified? I mean, whether you eat veg biryani or not, how does it matter? Okay? The question is, even if we follow procedures, it might not always result in fairness. Okay? So in 1978, for example, there was this lady called Menka Gandhi, right? Menka Gandhi, wife of Sanjay Gandhi. Menka Gandhi's passport was impounded, seized by the passport office under the Passport Act. She challenged the law and she was not allowed to go to a foreign country. So she challenged that law. Now till then, the court only checked the procedure. But in that judgment, the court said that no, the law under which she is not being allowed to move out of the country, that law itself is wrong. We have a right to check the law also. Okay. That gave us a very unique concept called due process of law. Please write this below. Due process of law. Now, what is the meaning of due process of law? due process of law is something called natural justice, meaning fairness. So we believe in fairness of laws. Okay, who makes laws? Legislature. So due process keeps a check on arbitrary legislative action. Procedure established keeps a check on executive. Due process keeps a check on legislature. Are we clear? Because we have to check whether the law is justified or not. Are we clear? So, check on legislature. And this becomes more important. And this due process has been in India since 1978. Okay? Please remember, I think we had discussed this point yesterday also, that procedure established is borrowed from Japan. And due process is borrowed from USA. So please remember this difference, that here rule of law is applicable. Yes, rule of law is applicable because we are placing limitation on the powers of state. Sir, what is bylaw? Bylaw means laws made by the local bodies. They are called bylaws. Laws made by societies, trusts, etc. are called bylaws. Are you clear? So, due process of law and procedure established by laws. Now, the beauty of Article 21 is that Article 21 says that no person shall be deprived of his life or liberty. What is life? Mere breathing, or something more than that? Life of dignity, respect, etc. So, Article 21 has been very widely interpreted by the Supreme Court. Very, very wide interpretation. So, please follow through all these things. We have seen multiple questions, though largely questions have been on this topic, right to privacy. There was a judgment called Putta Swami. Putta Swami, 2017, where Supreme Court said that right to privacy is a part of right to life. Or the very famous Hadia case, right to marriage. So you have a right to marry a person of your choice, but it is subject to condition that they should also want to marry you. That is very important actually. Okay. So right to marry, right to sleep that you use in the class a lot. You can claim next time that fundamental right. Please don't disturb me from sleeping. But don't use it in your UPSC Prelims day, especially the post-lunch session, the CSAT paper. After heavy food of chole bhature and idli dosa, then you sleep. Then right to reputation, right to information, right to hearing, all these are a part of Article 21. See, there will be something called right to travel abroad somewhere. That's the Menka Gandhi case. You can just mark it there. Second. This was Menka Gandhi. All these judgments, I mean, while discussing our mains aspects, we do go through all the judgments here because they are important for your mains answer writing. But for prelims, just know these points. What all things are a part of Article 21? That will be sufficient. Are you clear? Should we proceed now? So let's do one thing. Let's end our discussion here only. Tomorrow we will continue from the same point. And tomorrow we'll also discuss a very small topic called DPSP and fundamental duties. Okay? So that's all for me. Let's meet tomorrow. Right. And yes, now I hope all of you are aware that we will be having some questions to practice, so you can just practice questions. Those who don't know where it is, ask your friends. Please get to know. Yes, any doubts, online people, any issue, concern, please let me know now. Yes, others can leave if you want to. More interesting. Any doubts? Okay, so the app has a section called Vijayebhava, hopefully, right? I'm relying on the aspirants here. So you can find it there. Okay, that's all for me, guys.